Hello and welcome to a lecture on Wakf. Dear students, let us first understand the meaning of the word Wakf. The word Wakf has its origin in the Arabic word waqafa, which means to detain or to hold or to tie up. Though the word Wakf literally means detention, but technically in Islamic law, it means property which are inalienable that used for charitable purposes and pious endowments. The person who creates a Wakf is called a Wakif. It is undisputedly accepted that Holy Quran does not directly contain any direct verse relating to Wakf, but it is found scattered in several verses of the Holy Quran dealing with charity. For example, in verse 215 of the Surah 2, it is stated that, "They ask thee what they should spend in charity, say, whatever wealth ye spend, that is good for parents, kindred, orphans and those in want and for warfares, and whatever good ye do, that is good, Allah knoweth it well." Abu Hanifa, the famous Muslim jurist, defines Wakf as tying up of the substance of any property and handing over its ownership to Wakif and devotion of its usufruct for some charitable purpose. Accordingly, the right of the owner continues and the usufruct is to be devoted for some charitable purpose. But his two disciples do not agree to this definition. Accordingly, to them, Abu Muhammad and Abu Yusuf, the right of Waqif is transferred to Almighty God and profits of this property is used for the benefit of His creatures. Mostly, the view of the two disciples is taken as the correct one. So far as the statutory definition of Waqf is concerned, according to Section 2 of the Mussalman Waqf Validating Act 1913, Waqf means the permanent dedication by a person professing the Mussalman faith of any property for any purpose recognized by the Mussalman law as religious, pious or charitable. The Waqf Act 1954 also defines Waqf in the following words. Waqf means the permanent dedication by a person professing Islam of any movable or immovable property for any purpose recognized by the Muslim law as pious, religious or charitable. The concept of Waqf is a unique and striking feature of Muslim law which originated from Islam. Amir Ali says that the Waqf is the important branch of Muslim law. The reason is that it is interwoven with the entire Muslim law, society and its economy. There was no institution of Waqfs in Arabia before the advent of Islam, and credit must be given to the Muslim jurist for the development of jurisprudence of Waqf. The earliest example given by the legal authorities is that of Umar, the second caliph, and its basis of Waqf law. Waqf law is given importance not only in India but also in other countries where Muslim law is applicable. This is so because of commands of Quran and traditions of Prophet, peace be upon him, that encouraged Muslims to make waqfs. Though it was not compulsory for every Muslim to make waqfs of their properties, but traditions of Prophet encouraged every Muslim of the world to make waqf for different purposes. Even during the lifetime of Prophet, waqfs were frequently made and the Prophet himself made a waqf of land for the support of travelers. Several countries tried to control the increasing quantity of waqfs by legislation. Let us now talk about the constitutional provision of waqfs in India. The subject, waqf, is provided under entries number 10 and 28 of the Indian Constitution, which respectively deals with trust and trustees, charities and charitable institutions, charitable endowments and religious institutions in the concurrent list attached to the 7th schedule of the Indian Constitution. So, supervision over the administration of the Waqf is therefore the responsibility of both the central and state governments. Article 26D of the Constitution confers a separate fundamental right to religious institutions where a religious denomination has the right to acquire and own property and also to administer such property in accordance with law. The Mussalman Waqf Validating Act 1913 and the Waqf Act 1995 are examples of such law. Let us further understand the legislations relating to Waqfs in India. Some important legislations which directly or indirectly dealt with the Waqfs in India are: number 1, the Religious Endowment Act 1863, number 2, the Qazis Act 1864, number 3, the Charitable Endowments Act 1890, number 4, Sections 92 and 93 of the Code of Civil Procedure 1908, number 5, the Mussalman Waqf Validating Act 1913, number 6, the Official Trustees Act 1913, number 7, the Charitable and Religious Trust Act 1920, number 8, the Mussalman Waqf Act 1923, number 9, the Waqf Act 1954, and lastly, number 10, the Waqf Act 1995. In India, certain states had made their own corresponding enactments relating to Waqf. The Waqf Act of 1995 has repealed not only the Waqf Act 1954, but also the state enactments corresponding to the Act of 1995. Before the Act of 1995, the main pieces of legislation relating to the state Waqfs were: number 1, Bengal Waqf Act 1934, number 2, Bihar Waqf Act 1947, number 3, UP Waqf Act 1950, number 4, Bombay Public Trusts Act 1950, number 5, Dargah Khwaja Sahib Act 1955, number 6, Bihar and Orissa Mussalman Waqf Act 1926, number 7, Delhi Muslim Waqf Act 1943, number 8, Madras Waqf Act 1961, number 9, Bombay Mussalman Waqfs Act 1945, and number 10, Uttar Pradesh Muslims Waqf Act 1960. Now, let us talk about a very important act, the Waqf Act 1995. The new central legislation called the Waqf Act 1995 has been brought into force throughout the length and breadth of the country except the state of Jammu and Kashmir, with effect from 1st January 1996. It repealed all the Waqf laws except the Dargah Khwaja Sahib Act 1955. Some of the main features of the Act of 1995 are: number 1, establishment of a board of Waqfs for each state; number 2, distribution of powers between Waqf board and the chief executive officer who would be subordinate to the Waqf board; number 3, appointment of executive officer in respect of Waqfs whose performance is not satisfactory and whose annual income is Rs 5 lakhs or more; number 4, to strengthen the finances of the Waqf board; number 5, alienation of Waqf properties to be made difficult; number 6, restrictions on the powers of mutawalis in the interest of better management of Waqf properties; number 7, to bring uniformity in respect of Waqf administration throughout the country except the state of Jammu and Kashmir. Dear students, let us now discuss the kinds of Waqf. According to purpose of the Waqf and the property devoted to it, there are 3 kinds of Waqf recognized under Muslim law. Number 1, Waqf by user or public Waqf. Number 2, Mushratul Khidmat Waqf or quasi-public Waqf. Number 3, Waqf Alal Aulad or family Waqf or private Waqf. Let us go through each of the types separately. Number 1, Waqf by user or public Waqf. In public Waqf, primary objective is the permanent dedication of the property to some valid public work. The objects of these Waqfs must be religious, pious and charitable. When any piece of land or building has been used permanently for any religious or pious purpose, an owner has no objection to it or has an intention to allow continuing such practice, then such Waqf is called a Waqf by user. For example, mosque, madrasa, school, hospital. The second type of Waqf, Mushratul Khidmat Waqf or quasi-public Waqf, is a kind of public Waqf where the Waqif has devoted the property for the general benefit of Muslim community and means a grant stipulated for rendering services. Third type of Waqf, Waqf Alal Aulad or family Waqf, is made for the welfare of the Waqif's own family or children, That is why it's called Wakf alal Aulad or Wakf for progeny. Wakf alal Aulad or family Wakf were recognized by the Muslim law. The philosophy of Islam is that to support one's family and children is the first duty and necessity of every Muslim, so that they may not be a burden on the society. If the children and family would get into want and have nothing for themselves, they would obviously beg for their livelihood and would become a liability for the society. In order to avoid such unpleasant situation, a Muslim is allowed to make adequate arrangement for the maintenance of his children, descendants and family through the medium of a Wakf. As against the common notion that a charity means doing something for others, the Islamic philosophy sets an example of the English proverb, charity begins at home. Thus, the first class of Wakf would comprise what might be termed in modern law public trust of a charitable or beneficial character. The second class would comprise endowments for giving food, clothing or medical relief to the needy and particular community alone. And the third class is a family Wakf, which is in favor of a settler's family. Let us move a step ahead and discuss the essentials of a valid Wakf. The essential conditions for creating a Wakf is that the declaration of dedication should be made contemporaneously with the act of permanent dedication of property, and the Waqif must divest himself of the ownership of the property. Some of the essential characteristics of a valid Wakf under Muslim law are: number 1, Wakf must be perpetual or permanent dedication. Perpetuity is an essential characteristic of a Wakf, and a Wakf for a limited period or for a temporary purpose is not recognized by Muslim law. If a dedication is limited in time, then it is not valid. Hence, Wakf should be permanent dedication of property. For example, if Waqif says that this house of mine is a Wakf for the poor only and only for 1 month or 20 years, then this Wakf is void ab initio. Wherever the term Wakf is used, permanence will be presumed as a matter of law. About the implied permanency of a Wakf, there are 2 schools of opinion, Abu Hanifa's opinion and Abu Yusuf's opinion. Abu Hanifa maintained that to impart permanency, it must expressly mention that the ultimate benefit was reserved for the poor. However, Abu Yusuf was of the view that permanence was implied in the use of word Wakf by the settler. This view was followed by Amir Ali and also accepted by the Madras High Court in the case of Said Ahmad versus Juliha Bibi. But on the other hand, some high courts preferred Abu Hanifa's view. Now, the controversy is settled in favor of Abu Yusuf's view with the use of the expression expressly or impliedly, reserved for the poor or any other purpose recognized by Muslim law as religious, pious or charitable purpose of a permanent character. Second characteristic states that Waqf must be irrevocable. Once a Waqf is always a Waqf, and when a Waqf is validly constituted, then it is irrevocable. However, a testamentary Waqf operates only from the death of the testator, and there is nothing to prevent a man from revoking his will and making another one. Such a revocation is not revocation of a Waqf, but it is the only revocation of a will. It is important to mention here that on this issue there are also 2 schools of opinion. According to Abu Hanifa, a Waqf can be revoked by its founder unless the declaration has been confirmed by a court decree. On the other hand, Abu Yusuf took a contrary view and held that declaration of Waqf is in its nature irrevocable, and a Waqf cannot be revoked after the declaration has been made, nor can the power to revoke be validly reserved. Third characteristic mentions that Waqf must be inalienable. A Waqf cannot be transferred and is inalienable. As the Waqf property belongs to God, no human being can alienate it for his own purposes. Waqf property cannot be the subject of sale, mortgage, gift, inheritance, or any other type of alienation. The Waqf property may be exchanged for an equivalent property or even sold for compulsory reinvestment of the price in another property. The power of exchange and sale is subject to the permission of the court. It is germane to point out that it is the duty of the mutawalli to do everything that is necessary and reasonable to protect and administer the Wakf property. Legally, Mutawalli is not the owner of the Wakf property, but his position is that of manager only. Therefore, he cannot alienate the Wakf property without express authorization by the settler or the court. As Wakf property is dedicated to God, therefore its ownership is also transferred from donor to God. Fourth characteristic states that Wakf should not be contingent and conditional. A Wakf cannot be made to depend on the happening of a contingency, and if it is created on the happening of an event, then it is an invalid Wakf. For example, if the settler, a Muslim lady, creates a Wakf of her property for charity, in case she dies without leaving any issue, then it is invalid Wakf because it is dependent on contingency. And the last characteristic states that the object of the Wakf must be religious or charitable. The benefits of the Wakf property must be utilized only for such purposes which are recognized as religious, pious, or charitable under the Muslim law. Now, after going through the definition, the origin, the types, and characteristics of a valid Wakf, an important question comes into our mind with respect to Wakf, that who can create a Wakf, or what are the qualifications or capacity of a Wakf. Patently and normally, there are only two qualifications of a Wakf for creating a valid Wakf. Number one, he or she should be of sound mind, and number second, he or she should be major. A major person of sound mind can validly create a Wakf provided there is no fraud and the Wakif is not under influence or coercion. The Wakif should be the owner of the property that he is dedicating. He should not be suffering from death illness, marzul maut, and where he is suffering from such death illness, then he cannot dedicate more than 1/3 of his estate unless heirs give their consent to such Wakf. If some of his heirs consent while others do not, then the Wakf is valid in proportion to the shares of the consenting heirs. On the other hand, if all his heirs give consent, then whole property is covered by the Wakf. Now, let us further enlighten ourselves about the right of the Wakif. When a Wakf is created, all rights of property pass from the Wakif and vest in Almighty God. But a Wakif may, however, reserve certain rights in respect of created Wakf. The rights of the Wakif are: number one, right to appoint Mutawalli. Mutawalli of a Wakf is merely a manager or superintendent of the Wakf property, and Wakf property does not vest in the Mutawalli but in God. Anyone, male or female, which is competent to administer property may become Mutawalli, but where religious duties are involved, a person of another religion or a woman may be disqualified. The Wakif has the right to appoint a Mutawalli during his lifetime or whenever he likes. It is important to note that in case of private Wakfs, the Wakif has absolute rights to appoint a Mutawalli, but in case of public, charitable or religious Wakfs, right may be subject to the approval of court. Number second, right to reserve superintendence of Wakf to himself. Wakif may constitute himself as the first Mutawalli and even lay down a scheme of succession to the office of Mutawalli. Number third, right to remove Mutawalli. Settler has the right to remove Mutawalli provided such a power has been reserved at the time of creating a Wakf. In other cases, the court has the power to remove a Mutawalli on the ground of misfeasance, breach of trust, or for his unfitness or for any other valid reason. Number 4. Right to delegate power. The settler has the right to allow the Mutawalli to appoint a co-Mutawalli or any other Mutawalli. Number 5. Right to use the usufruct of the Wakf property. The Wakif may reserve a right to use the usufruct of the Wakf property in any way he likes during his lifetime only. He may provide for his maintenance or for the payment of his debts from the income of the property. Number 6. Right to alter beneficiaries or their interest in the Wakf. He may reserve the right to alter the beneficiaries or their interest in the Wakf, or to add the beneficiaries or to name the beneficiaries subsequent to the execution of the Wakf. And lastly, number 7, right against Wakf property. He has the right to make a condition to the effect that the Wakf premises may be exchanged for another property, or they may be sold and the sale proceeds be applied for the purpose of the Wakf. Now, let us try to understand the advantages and disadvantages of Wakf. The advantages of Wakf include: property belongs to God. The religious motive of a Wakf is that the Wakf property belongs to Almighty God. So, this is the religion's advantage of Muslim faith. Eradication of poverty. Wakf, to some extent, eradicates poverty by providing money to the poor persons. Community services. By creating Wakf, some money or property is given to an Eidgah or mosque or other religious places where Muslims perform community services. Preservation and maintenance of old and historical places. By creating Wakf, there is easy maintenance and repairs of Imam Baras, Khanqah, etc., and by such act, identity of some historical places can be maintained. Now, here are some disadvantages of the Wakf. First disadvantage is, people depend on charitable aids. A charitable aid often keeps people away from industry, and lethargy breeds degeneration. People do not take interest in the hard work and they largely depend upon the charitable helps. Second disadvantage is black marketing. Some people who desire fame by making foundations, endowments and Wakf obtain property by shady means amounting even to extortion and exploitation. So, in this way, some people from black marketing's field enter into the sphere of Wakf. Third disadvantage is mismanagement of Wakf. The mismanagement of Wakf due to worthlessness of mutawalis and of the destruction of Wakf property has often come before the courts. Considering all these matters, it can be said that institution of Wakf as a whole has been an unmixed blessing to the Muslim community. Moving further, let us now understand the object and purpose of Wakf. Wakf may be for benefit of person or for any object of piety and charity. The term charity includes every purpose which is recognized as good or pious. Every good purpose which God approves is a fitting purpose for a valid and lawful Wakf. The real purpose of making a Wakf is to acquire merit in the eyes of the Lord, and all other purposes are subsidiary. Therefore, every purpose considered by the Muslim jurisprudence as religious, pious or charitable would be considered valid. Thus, object of a Wakf may be religious, charitable or private. Religious and charitable objects. Objects of the Wakf should be religious and charitable and should not be in conflict with the general religious policy of Islam. Charitable objects include giving to one's own family and descendants and such things in which rich and poor are equally interested in, for example, mosque, dargah, khanqah, college, school, hospital, roads, bridges. Private objects. Wakf in favor of one's own family may be treated as private Wakf or private objects Wakf when the Wakf is exclusively for the benefit of Waqif's own family, when the Wakf is substantially for the family with some provision for charity, and lastly when the Wakf is substantially for charity with some provision for the family. Let us now further go through the valid and invalid objects of a Wakf. A renowned jurist has given a long list of valid and invalid objects of Wakf on the basis of judicial decisions. The valid objects of a Wakf are: number 1, mosques and provision for imams to conduct worship therein. Number 2, distribution of alms to poor person and assistance to poor to enable them to perform the pilgrimage to Makkah. Number 3, celebrating the birth of Ali Murtaza. Number 4, keeping taziyas in the month of Muharram. Number 5, repairs of Imam Baras and maintenance of Khanqah. Number 6, celebrating the death anniversaries of the settler and of the members of his family. Number 7, reading the Quran at public places and also at private houses. Number 8, construction of a free boarding house for pilgrims at Makkah. Number 9, payment of money to fakirs. Number 10, grant to an Eidgah and burning lamps in a mosque. Some of the invalid objects of a Wakf are: number 1, objects prohibited by Islam, for example, constructing or maintaining a church or a temple. Number 2, a waqf in favor of utter strangers, though there was an immediate and substantial gift to charity. Number 3, according to Shia law, a provision for the repair of the waqf's secular property is invalid. Number 4, a direction to spend a certain amount of money for feasting Kachi Memons every year on the anniversary of the settler's death is not valid object. Let us now try to understand the ways in which a waqf is created. According to Islamic law, there is no obligation on a Muslim to create a waqf. It is discretionary and not compulsory. Abstinence from waqf leads to no penalty or detriment. However, creation of waqf for the benefit of mankind or Muslim community would no doubt entail reward in perpetuity. A waqf may be created in the following ways. Number 1, creation of waqf by inter vivos. Number 2, creation of waqf by will. Number 3, creation of waqf by immemorial use. And number 4, creation of waqf during illness. Now, let us discuss each of them separately. Number 1, creation of waqf by inter vivos. The term inter vivos means between the living voices, and it also means during the lifetime. Thus, a waqf by an act of inter vivos is a waqf which is constituted during the lifetime of the waqif. There is no essential formality for the creation of waqf. It is not necessary that a waqf should be made in writing. Some sort of declaration, either oral or in writing, must be made to constitute a waqf. Where dedication is intended, it is given effect to, in whatever language it may be expressed or in whatever terms this wish may be formulated. So far as the registration of waqf is concerned, no registration is required for a waqf deed, but when it relates to an immovable property worth more than ₹100, registration is essential. Second creation is creation of waqf by will. A waqf can also be created through a testament containing the desire of the waqif to take effect after his death. Testamentary waqf is valid to the extent of the bequeathable of 1/3 of the property. A testamentary waqf in excess of 1/3 of the property is void unless the heirs of the waqif give their consent to the waqf in excess of such 1/3. Thus, neither the use of word waqf nor express dedication of the property to the ownership of God is essential for the creation of waqf. Even any implied expression is enough for the creation of waqf. For example, if a man says, "This is my land and same is dedicated and consecrated not to be sold, inherited or given by gift," all these words would create a valid waqf. A waqf cannot be made for an illegal object, for example, to delay or defeat creditors. Number 3, creation of waqf by immemorial use. Waqf is also created by long and immemorable use. Where there is no evidence to show how and when the waqf was created, then waqf may be established by evidence of longer use. The Supreme Court in Muhammad Shah versus Fasiuddin Ansari held that a land adjacent to a mosque would become a waqf by use if it had been used by public for religious purposes along with mosque. Creation number 4, creation of waqf during illness. A waqf created during death illness is considered a disposition like will, and under the same rules and restrictions of not more than 1/3 of waqif's property may be given in waqf, unless heirs consent it. Such a waqf is like a bequest to charity, with same restriction as that of a bequest to an individual. When all heirs give their consent to a waqf during death illness, it is valid for the whole property. With this, we come to the end of the lecture. I hope everything is clear. See you next time. Thank you.